when it comes to this lawsuit, man, if this was something that was just about money, really about money, when it came to, you know, people sue their record labels all the time when they feel like they aren't getting what they're owed money-wise. But this right here was just a petty attack to the label for not protecting him like they have in the past when it came to different beefs that Drake has been in. We've been covering this for damn near a whole damn year. We know we've gone through so many different things. We know that UMG would normally stand and protect Drake, put anyone he's going against, put their hands behind their backs and let Drake just haul off on their ass. They did that to Pusha T, although Pusha T won on social media when it came to the actual business. Over time, UMG did their best to block things that Pusha T was doing, especially working with other artists that was affiliated with UMG. So we know how they move for Drake. They've been doing so many different things for Drake. So when it came to this lawsuit, we know what was going on. Him just being salty because they weren't doing things that he was asking them to do, such as not allowing the song to stream, not putting the back behind the song like they do with any other great single, because organically, Not Like Us was going crazy, doing what it should do after the biggest diss rap beef that we've seen in damn near ever, especially with the social media times. The song was out of there. So he was upset that UMG was doing proper business and putting funds and fueling the song to continue growing as a damn single like they're supposed to do. But it's at his expense because he was on the receiving end of some scathing disses, all right? So he wanted UMG to help. He wanted them to take down also the artwork that showed his house with all the pedophile apps on his home. You know, it was so many different things that he wanted them to stop the bleeding, and they felt like it would be a conflict of interest because Kendrick Lamar is one of their big artists too. You have the two biggest rappers in the world, both on UMG, going at it. You gotta just let that shit happen, and you do your thing business-wise. He didn't want them to make money off of it, and he wanted to be protected. So that's what we doing. That's how we got to this damn lawsuit, because it was much more of a petty move. But so many damn people was trying their best to defend this shit. I don't know why. The Neat Broward County in the building was good. Paul, what's good, homie? I don't know why they were trying to defend this, but here we are. We got the paperwork, man. What Wack 100 be saying? We got the paperwork over here. We got the paperwork. We're gonna read through this thing and go through it, comb through it, and see what the hell was going on. Let me make sure we on the right screen. My bad for the swooches y'all about to be hearing. Y'all can see everything right there. So it is 30-something pages. Hopefully this ain't too boring, but the judge looked like she was writing this thing like a damn. She was trying to put her old back in this shit. She was saying some stuff. All right, shoot me. So it says opinion in order. R.B. Graham versus UMG Records. Jeanette A. Vargas, United States District Judge. So it says this case arises from perhaps the most infamous rap battle in the genre's history. The vitriolic war of words that erupted between superstar recording artist Aubrey, Drake Graham, and Kendrick Lamar Duckworth in the spring of 2024. Over the course of 16 days, the two artists released 8 so-called diss tracks with increasingly heated rhetoric, loaded accusations, and violent imagery. The penultimate song of this feud, Not Like Us by Kendrick Lamar, dealt the metaphorical killing blow. The song contains lyrics explicitly accusing Drake of being a pedophile to set a catchy beat and propulsive bass line. Not Like Us went on to become a cultural sensation, achieving immense commercial success and critical acclaim. Both Drake and Kendrick Lamar have recording contracts with defendant UMG Recordings. Drake alleges that UMG intentionally published and promoted Not Like Us while knowing that the song's insinuations that he has sexual relations with minors were false and defamatory. Drake has brought this action against UMG for defamation, harassment in the second degree, and violation of Section 349 of the New York General Business Law. Before the court is defendant's motion to dismiss pursuant to Rule 12b-6 of the Federal Rules of Civil Procedure, because the court concludes that the allegedly defamatory statements in Not Like Us are non-actionable opinion. The motion to dismiss is granted. All right, that's what they saying. This thing is granted. We finna read through this thing more. Giles Star says he a fan. Y'all laughing in the chat. Anthony, what's good, man? What's good? What's good? We finna read this thing some more. So once again, talk y'all shit in the chat because we do talk back. So there's a reason why I always wear hats in my videos, bro. And it's not because I'm trying to be cool or mysterious. It's because I got this permanent scar on my forehead from a car accident that pretty much messed up my hairline, bro. And it's been years and I've never been compensated for it. Why? Because I didn't have a lawyer. I thought it'd be too expensive or just take forever. So instead of justice, I just got trauma in the crooked hairline, man. Back then, getting legal help felt like filing taxes blindfolded. Too much paperwork, endless phone calls, confusing appointments. I gave up before I even started. But now I know there's a reason why I keep my hat collection stacked up. Just like there's a reason that Morgan & Morgan is America's largest injury law firm. When life hits you hard, you need someone who hits back harder. And Morgan & Morgan, that's a legal powerhouse.
Morgan & 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 Morgan.
They've got over 1,000 attorneys in all 50 states. Real talk, they've recovered over $25 billion for over 500,000 clients. Like in Florida, someone was offered $350K and Morgan & Morgan got them $12 million. Another case in Pennsylvania offered $500,000, walked away with $29 million. So yeah, not all law firms are built the same, man. And submitting a claim is super easy. You can go to forthepeople.com/Stacy. All you have to do is provide your name, phone number, zip code, email, the class type, pick one of these things right here, and then describe what happened and start your claim. It's simple like that. It literally takes under a minute. You don't have to get on a phone call, sit in the office, or fax somebody like it's 1999, dog. You can do it right up from your phone or your laptop. So if you're ever injured, you can check out Morgan & Morgan. Their fee is free unless they win. And once again, you can just click the link in the description below or scan the QR code on the screen to start your claim. Don't be like me, scarred up and empty-handed, man. Be smart and be ready. All right, what else? So, all right. So they talk about the legal standard. So to survive a motion to dismiss, a complaint must contain sufficient factual matter accepted as true to state a claim to relief that is plausible on its face. All right. So they use some case law to talk about the legal standards. We're going to just skip past this right here. But all right. We're going to try to get it's all these things just talking about case law and different references to different things. But let me read a little bit of this as far as the background. So the following background is largely taken from the allegations in the amended complaint, which are assumed true for purposes of this motion. Additionally, defendant requests the court take the judicial notice of certain extrinsic evidence pursuant to Rule 201 of the Federal Rules of Evidence. These exhibits include the lyrics of songs released as a part of Drake and Kendrick Lamar's rap battle, the dates on which these songs were released, and the lyrics of these songs are not reasonably subject to dispute. See Pickett versus Migos touring. So they reference some other things. It's all case law stuff, trying to see what was done in the past that set precedents and how you use that to make a decision on this case. And that ultimately led to a dismissal. So I'm trying to skip that more down to what they're saying. All right. So factual allegations. Drake is a prominent recording artist and songwriter among other public-facing endeavors. Drake has had a successful music career under defendant UMG for at least 20 years. UMG uses its brands and imprints or labels to provide its music artists with the means to create, promote, and distribute their music commercially. Defendant through UMG uphold exclusive publishing and distribution rights to Drake's music as well as that of artist Kendrick Lamar. So on April 19th, 2024, Drake released a diss track directed at Kendrick Lamar called Push-Ups. All right. Drake mocks Kendrick Lamar's height and shoe size. How the f you big stepping with a size 7 men's on Pipsqueak pipe now? Hey, just seeing this shit in court, it's hilarious. I ain't gonna lie to y'all, man. And the judge did a research. She probably was lit. She probably was lit, having a good time going through this whole beef. I know she probably had the stank face several times, especially when she got the goddamn Euphoria, when she understand the background. Euphoria probably had it with a permanent stank face. But all right, let me keep my composure and keep reading for y'all. All right, so he questions Kendrick Lamar's success. You ain't in no big three. I'm at the top of the mountain, so you tight now. Just to have this talk with your ass, I had to hike down. A few days later, Drake released Tailor-Made Freestyle, in which he used artificial intelligence generated voices of deceased rapper Tupac and of rapper Snoop Dogg to goad Lamar. In the track, Tupac and Snoop Dogg shared their disappointment that Lamar had not yet responded to Push Up. So, Kendrick, we need you, the West Coast savior. You seem a little nervous about all that publicity. You got to show this Al, who's boss on the West, Drake in his own voice further taunts Kendrick for failing to come up with a satisfactory response, saying, I know you're in that New York apartment, you're struggling right now, I know it, in the notepad doing lyrical gymnastics, my boy. Drake also surmises that Kendrick was purposefully delaying his response because artist Taylor Swift had just released a new album. Shout out to Taylor Swift, biggest gangster in the music game right now. She had the whole PG Lang on mute like the Beyonce challenge. Y'all boys quiet for the weekend. So Lamar fired back at Drake in Euphoria, which was released April 30th, 2024. In the track, Lamar claims, I made music that electrify him, you made music that pacify him, and that he would spare Drake this time. That's random acts of kindness. So he accuses Drake of fabricating his claims. Know you a master manipulator and a habitual liar too, but don't tell no lie about me and I won't tell truths about you, alright? So he insults Drake's fashion sense. I hate the way that you walk. Hey, the judge funny. I know this, like she got to do this shit, but it's interesting. It's interesting to see the lines that she wanted to highlight as she putting this shit together, alright? I hate the way that you walk, the way that you talk. I hate the way that you dress. Further raps, I believe you don't like women. It's real competition. You might pop an ass with them. And taunts Drake for being a coward with his response. I hate the way that you sneak this. If I catch flight, it's gonna be direct, all right? On May 3rd, 2024, the feud between Drake and Kendrick Lamar escalated as they lobbed increasingly vicious personal accusations at each other over the course of the day. First, Lamar released 616 in LA, in which he calls Drake a terrible person. Lamar accuses Drake of playing dirty with propaganda and raps that if Drake was street smart, then he would have caught on that his entourage is only there to hustle him. Drake's next response arrived later that day in Family Matters. Drake jabs at Lamar's relationship with his partner. You the black messiah wifing up a Miss Queen, a hit vanilla cream to help out with your self-esteem. On some Bobby, I want to know what Whitney need, and implies that Lamar physically abused her. You a dog and you know it. You just play sweet. Your baby mama captions always screaming, save me. You did a dirty all your life. You trying to make peace. Moreover, Drake calls into question whether Lamar is the biological father of one of his children. I heard that one of them little kids might be Dave Freeze. Don't make it Dave Freeze. You see how the judge is putting this shit in order, but on social media, motherfuckers try to put this shit out of order as far as who was taking the digs towards the family first. Y'all see what we doing, but the judge did the research, man. Shout out to the judge. Shout out to the judge, man. All right, so to continue, almost immediately after the release of Family Matters, Lamar unleashed the scathing Meet the Grams, in which he accuses Drake of being a deadbeat father and hiding the existence of other children. You lied about your son, you lied about your daughter, huh? You lied about the other kids that's out there hoping that you come. Lamar also alleges that Drake has gambling problems, drinking problems, pill popping and spending problems, bad with the money, whorehouse, soliciting woman problems, therapy's a lovely start. Oh, I know this judge loved this shit. It's probably one of her favorite cases. He further insinuates that Drake was a predator and that Drake should die so all these women can live with a purpose. The next day on May 4th, 2024, Lamar released Not Like Us. Not Like Us explicitly names Drake and his associates as pedophiles. Specifically, the track contains the following lyrics. Say Drake, I hear you like I'm young. You better never go to cell block 1. To any bitch that talk to him and they in love, just make sure you hide your little sister from him. They tell me Chubb's the only one that get your hand-me-downs and party at the party playing with his nose now. And Baca got a weird case. Why is he around? Certified lover boy, certified pedophiles. Wop, wop, wop. Okay. Wop, 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 wop. Dot him up. My bad, I was getting too into it. Wop, 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 wop. I'm gonna do my stuff. Why you trolling like a ain't you tired? Trying to strike a chord and it's probably a minor. All right. So on May 5th, 2025, Drake responded in The Heart Part 6. Directly denying Lamar's allegations of pedophilia. I've never been with no one underage, but now I understand why this angle that you really mess with. Just for clarity, I feel disgusted. I'm too respected. If I was smashing young girls, I promise I'd have been arrested. I'm way too famous for this shit that you just suggested, all right? Drake is not a name that you're going to see on no sex offender list. In the track, Drake further sneers that the Epstein angle was that I expected and accused Lamar of wanting to misdirect. Drake also alleges that he had planted some of the information Lamar used against him. We plotted for a week and then we fed you the information, but you so thirsty that you're not concerned with investigation. You gotta learn to fact check things and be less impatient. So Not Like Us was a huge commercial success. It has gained immense popularity on streaming and social media platforms. It has streamed globally more than 1.4 billion times on Spotify alone as of April 2025. On November 8, 2024, the Recording Academy nominated Not Like Us for several Grammy Awards, and in February 2025, it won Record of the Year. A week later, on February 9, 2025, Kendrick Lamar performed Not Like Us live during the Apple Music Super Bowl halftime show. The performance is alleged to be the most watched Super Bowl halftime show of all time, over 133.5 million views. All right, so that all right there was the judge going through the factual allegations, man. What y'all saying in the chat, dog? Y'all laughing y'all ass off. The judge cooked this. Shout out to the judge. The judge probably two-stepping to Not Like Us. The judge had the ball. This had to be her favorite case. Had to be her favorite case. If she ain't, I wonder if she was in tune with it for the rap battle. Judge had a ball putting this shit together. This shit read like a damn Rolling Stones article. Shit crazy. All right, so to continue, let's continue. So procedural history. So plaintiff brings claims for defamation, harassment in the second degree, and violation of New York General Business Law Section 349, based upon UMG's publication and promotion of Not Like Us. Defendant has filed a motion to dismiss the amended complaint. The court heard oral argument from both parties concerning the motion to dismiss and the request for judicial notice. So plaintiff contends that he was defamed when defendant decided to publish, promote, exploit, and monetize allegations that it understood were not only false, but dangerous. Plaintiff alleges that the recording repeatedly accuses Drake of engaging in criminal acts, including pedophilia and or acts that would require registering as a sex offender and of being registered as a sex offender. The amended complaint alleges that the song implies that Lamar has heard, albeit from undisclosed sources and concerning undisclosed individuals, that Drake has a predilection for underage women. My bad if I said the word the wrong way. According to the amended complaint, the reference to Cell Block 1 is a thinly veiled threat that Drake should be careful that he never ends up in prison, a place where child predators are notoriously the targets of violence. The line Certified Lover Boy, Certified Pedophiles is a perverse reference to Drake's 2021 album Certified Lover Boy. Plaintiff argues that the use of the term certified communicates that Drake has been found to be a pedophile. And the final line of this passage plays on a dual meaning of minor, a person under the age of 18, and a musical scale. All right, so plaintiff further cites as defamatory that the recordings descriptions of Drake as Malibu Most Wanted and the Predator, and that his name got to be registered and placed on Neighborhood Watch. So the associated music video shows images associated with sex trafficking to reinforce the pedophilia accusation. The recording is also accompanied by an album image of Drake's home in Toronto, which is plastered in icons used by law enforcement in public safety applications to denote the residences of registered sex offenders. So discussion. All right, here goes the discussion. All right, so under the defamation claims. So under New York law, the elements of a defamation claim are: 1, defamatory statement of fact regarding the plaintiff published to a third party that is false, made with applicable level of fault and causing injury and not protected by privilege. All right, so they reference this case, Live Face on Web, LLC versus 5 Borough Mode. This is referenced a lot. So defamatory statement is one that exposes an individual public hatred, shame. We all know this stuff already. All right. So the issue in this case is whether or not Like Us can reasonably be understood to convey as a factual matter that Drake is a pedophile or that he has engaged in sexual relations with minors. In light of the overall context in which the statements in the recording were made, the court holds that it cannot. It cannot. Okay. So a fact versus opinion. Under the First Amendment, there's no such thing as a false idea. Okay. That's Gertz versus Robert Welch. That's the reference to that. All right. Only assertions of facts are capable of being proven false. Okay? So moreover, the New York Constitution provides for absolute protection of opinions. So if what Kendrick Lamar was voicing is an opinion, it's safe. It's safe. Okay? Thus, courts must distinguish between statements of fact, which may be defamatory, and expressions of opinion, which are not defamatory, and have the full protection of the New York Constitution. They reference that live face case one more time. So whether a challenge statement is a fact or opinion is a legal question. It's a legal question. They reference this case right here. So plaintiff argues that it is inappropriate for the court to determine at the pleading stage whether a reasonable listener would perceive the recording as fact or opinion. Remember, once again, I told y'all it was going to come down to whether the judge believed that a reasonable listener, like you and me or anyone that's listened to the track, listened to the diss songs, will obviously know that this is a diss. This is known to be hyperbolic in nature. Rap is hyperbolic in nature, and they would know based on everything they know why Kendrick Lamar is calling Drake a pedophile. Of course, he hasn't been, going through a trial and found guilty of pedophilia or dealing with a minor. Of course, we know this is this song. We understand the context. So she has to make a decision like, should this even go to a jury when a reasonable listener will understand the context of this battle? All right. Bet. So let's continue reading. So, yet because this is a question of law, New York courts routinely resolve this question at the motion to dismiss stage. So they reference Bryan versus Richardson, holding on to motion to dismiss. The challenge statement constitutes opinion. So whether a statement is fact or opinion is a question of law for the courts to be decided based on what the average person hearing or reading the communication would take it to mean, and is appropriately raised at the motion to dismiss stage. All right. So holding that because whether a statement is defamatory presents a legal issue to be resolved by the court. Defamation's actions are particularly suitable for resolution on a motion to dismiss. So there is a particular value in resolving defamation claims at the pleading stage so as not to protract litigation through discovery and trial, and thereby chill the exercise of constitutional protected freedom. So basically, UMG, not UMG, Drake's team, they think the judge shouldn't be able to decide that. You should let it go to a jury, so the jury could decide that and allow us to continue doing our discovery, pulling all the information that we asked for. The judge is like, I could decide that based on case law, so we don't have to continue doing all the discovery and, protect these people's freedoms and shit like that. All right, let's continue reading. So in distinguishing between facts and opinions, 3 factors guide the court's consideration. So whether the specific language in issue has a precise meaning which is readily understood, whether the statements are capable of being proven true or false, and whether either the full context of the communication in which the statement appears or the broader social context and surrounding circumstances are such as to signal readers or listeners that what is being read or heard is likely to be opinion, not fact. So they reference this case right here. The court conducts this inquiry through the lens of a reasonable listener. So plaintiff's suit is focused on a single factual message conveyed by the recording, the false allegation that Drake is a pedophile. But the recording is myopically focused on ensuring that listeners take one message away from the song: Drake is a pedophile. The statement has a readily understandable meaning and is capable of being proven true or false. But even accusations of criminal behavior are not actionable if understood in context. They are opinion rather than fact. So thus the court will focus its analysis on the third factor. That's why I emphasize this right here. The third factor up here. This inquiry is a holistic one, which looks to the overall context in which the assertions were made. So in order to assess the impact that the statements would have on a reasonable listener, context includes the form in which the communication was published, the surrounding circumstances, the tone and language of the communication, and its apparent purpose. Basically, these in a rap battle. Of course, he gonna say some disrespectful shit. And we know the nature of hip hop. It's disrespectful. It's hyperbolic in nature. When they are battling, they be lying. And many of the readers, the listeners, understand are going to talk trash and exaggerate shit. And of course, if you got footage out there of you kissing a 17-year-old after you found out that she was 17, and saying how her breasts felt pressed against your body, of course it's gonna call you a pedophile in a rap battle. Of course. Of course. So the judge is looking at all this shit, like, in the context of this shit, you even told it on Telemade to go with that angle. You even told him to do this shit. Of course he gonna do this shit. The fuck are we talking about? All right, let me continue reading. All right. So the form. To start, the court considers the form in which the allegedly defamatory statements appear as that it is a useful gauge for determining whether the reasonable reader will treat it more readily as opinion than fact. For example, the average listener is more likely to understand statements made on a news program in a journalistic piece to be factual, while statements made in the opinion of a newspaper or an internet comment page are generally perceived as opinion. They reference this case right here. Appearance of a statement on editorial page indicative of opinion. So the common expectation is that the columns and articles published on newspapers' op-ed sections will represent the viewpoints of their authors and as such contain considerable hyperbole. I keep telling y'all, rap hyperbolic in nature. Considerable hyperbole, speculation, diversified forms of expression and opinion. All right. The culture of internet communications as distinct form that print media, such as newspapers and magazines, has been characterized as encouraging and freewheeling anything goes writing style. So basically what she's saying, when you pick up a newspaper versus a magazine, I remember as a kid when I would go on Hip Hop DX, you have them reporting news, some sections, but then they'll distinguish when something is an editorial. An editorial is when the writer shares their opinion and they get more free with how they're speaking on the subject rather than just delivering facts. So if someone says something in an editorial, you know it is an opinion. It's not like someone delivering news or breaking news or whatever. It's a distinguished thing, and someone should allow someone to express themselves and not hold them to the same standards as a journalist saying everything has to be fact checked here because it's all opinion. All right. So that's what's going on when she's referencing, while the judge referencing the other case that talks about editorials versus facts. So Twitter conveys a strong signal to a reasonable reader that this was the defendant's opinion. So the media vehicles used to disseminate the alleged defamation, a WordPress blog, social media post, and an unsigned press release complaining about litigation tactics suggest to readers that they contain opinions, not facts, and they are written in an amateurish fashion. The form in which the statement appears is not dispositive of the fact versus opinion inquiry, but it does provide contextual indicia that can inform the court's analysis. The form here is a music recording, in particular a rap diss track with accompanying video and album art. Diss tracks are much more akin to forms like YouTube and X, which encourage a freewheeling anything goes writing style, than journalistic reporting. All right. And I'm glad about this because the big thing about this whole lawsuit was that it was nasty. It was nasty as far as in taste. You taking something that's cultural, well known what's going on here. You are slanging mud back and forth. Culturally, we understand what's going on with this shit. But you want to take this shit to a judge who may not understand culturally what's going on and try to get them to regulate the diss track. That's foul. That's foul. That's foul. And that's a lot of people frown upon that and I understand why. Because why would you do that? Why would you do that? So the judge, thank God, because this what the implications that if this shit would have went through and how it would have changed just music period would have been crazy. We'll get to that later. But the judge, I'm glad she did her research and dove into the context of what's really going on to understand what's a diss track and wasn't just green about it. You know, wet behind the ears about this shit. You feel me? All right. Y'all say Drake tried to take the whole culture down with him. Yeah, man. Yeah, he's trash. Weakest I ever seen in hip hop. And I thought for a minute what Cole did was that to sue over a battle you started. Nah, B. Go on YouTube and you're the first video I say, what's good, Gwen? Someone said Drake lost the black way and the white way. Hey, y'all crazy, man. All right, let's continue. Surrounding circumstances. Next, the court considers the full context of the communication in which the statement appears, including the settings surrounding the communication. So the fact that the recording was made in the midst of a rap battle is essential to assessing its impact on a reasonable listener. So even apparent statements of fact may assume the character of statements of opinion when made in a public debate, heated labor dispute, or other circumstances in which an audience may anticipate the use of epithets, fiery rhetoric, or hyperbole. So as context is key, so she's referencing another case. This is a Trump case. So Jacobus versus Trump. So it says, as context is key, defamatory statements advanced during the course of a heated public debate, during which an audience would reasonably anticipate the use of epithets, fiery rhetoric, or hyperbole are not actionable. All right. So the decision by the New York Court of Appeals in Steinhilber is instructive in this regard. In Steinhilber, the allegedly defamatory statements were published in a tape-recorded telephone message that was played automatically to anyone dialing the private phone number that was given to labor union members. So the union had assessed a fine against plaintiff after she had defied a strike order, and the phone message appeared after she had failed to pay the fine. So the New York Court of Appeals found that the most significant circumstance was that the message was prepared and played as a part of the union's effort to punish a former member. So the court highlighted that in the emotional aftermath of a strike, when animosity would be expected to persist, particularly against a former member who was seen as a traitor to the cause, that a listener would not expect that any insults lobbed will be factual in nature. So that's what she's referencing, another case where y'all just read out. We understood. All right, bet. So she referenced another case right here. The Second Circuit affirmed the dismissal of a complaint at the pleading stage, holding that as a matter of law, comments that the plaintiff was a sick, racist pedophile, a loser pedophile, a broadcaster pedophile, a child predator, a lunatic, that he must be put behind bars, were expressions of opinions. In reaching this conclusion, the Second Circuit relied upon the context in which the statements were made. Specifically, the comments were part of a war of words between disc jockeys at rival radio stations that received extensive media coverage and commentary. That's another thing she's referencing. As a part of that feud, the plaintiff made comments on air suggesting that he would sexually abuse the minor daughter of the defendant. The Second Circuit concluded that in this context, no reasonable listener could have perceived the defendant's responses to state or imply assertions of fact, of objective fact. Wait, what the hell is going on in this case, bro? What the nigga say he would do what to who? That sound crazy. I don't know. They say terrain versus loot. That sound crazy as hell. All right, but let's continue. So she just continues referencing different cases that help her come up with her decision. All right. So just as in Steinhilber or Rappaport or in Terrain, the recording was published as a part of a heated public feud in which both participants exchanged progressively caustic, inflammatory insults and accusations. This is precisely the type of context in which an audience may anticipate the use of epithets, fiery rhetoric, or hyperbole, rather than factual assertions. A rap diss track would not create more of an expectation in the average listener that the lyrics state sober facts instead of an opinion than the statements at issue in those cases. So, for example, in Euphoria, Lamar called Drake a master manipulator and habitual liar and a scam artist. Drake responds to Family Matters by heavily implying that that Lamar is a domestic abuser. He also raps that he heard that one of Lamar's sons may not be biologically his. So why you never hold your son and tell him stay cheese? We could have left the kids out of this, don't blame me. I heard that one of them little kids might be Avery. So in Meet the Grams, Lamar take issue with Drake involving his family members in their feud. Thank you, Judge, for getting this right, man. So, dear Aubrey, I know you're probably thinking I wanted to crash your party, but truthfully, I don't have a hating bone in my body. This is supposed to be a good exhibition within the game, but you at the moment you called out my family's name. Why you had to stoop so low to discredit some decent people? In that same track, Lamar alleged that Drake uses the weight loss drug Ozempic. Don't cut them corners like your daddy did. Fuck what Ozempic did. Don't pay to play with them Brazilians. Get a gym membership. Lamar also insinuates that Drake knowingly hires sexual offenders, so grew facial hair because he understood being a beard just fit him better. He got sex offenders on Hovio that he keep on a monthly allowance. Of particular relevance in Telemade Freestyle, Drake challenged Lamar to make the pedophilia accusations at issue. Using the AI generated voice of deceased rapper Tupac, Drake goes to Lamar, Kendrick, we need you, the West Coast savior, engraving your name in some hip hop history. If you deal with this viciously, you seem a little nervous all about the publicity. Fuck this Canadian light skinned doc. We need no debated West Coast victory, man. Call him a bitch for me. Talk about him liking young girls. That's a gift from me. Heard it on the Button podcast. It got to be true. So it is in this context in which the lyrics say Drake, I heard you like him young. I hear you like him young. I hear you like him young. From the recording must be assessed. The similarity in wording suggests strongly that this line is a direct callback to Drake's lyrics in the prior song. The judge is cooking this shit, dog. It's all right there. It's not that hard. It's not that hard. That's why I'm surprised that we even got this far with this damn lawsuit. It's all right there. You told him to say this shit. You told him to say this shit. He said this shit. And then you gonna sue him for it? Come on now, man. Come on now, bro. Come on now, bro. And Drake's legal team was trying their best to just ignore that whole context. Come on now, bro. All right. So plaintiff argues the court should see, here you go, right here. The judge is cooking this shit, dog. This is crazy. So plaintiff argues that the court should ignore the songs that came before, assess Not Like Us as a singular entity, and assess Not Like Us as a singular entity. Plaintiff argues that the average listener is not someone who's familiar with every track released as a part of the rap battle before listening to the recording, because the recording has achieved a level of cultural ubiquity far beyond the other 7 songs. Plaintiff contends that the court should not consider those other tracks in assessing how the average listener of the recording would perceive the allegations regarding Drake. There are a number of flaws with this argument. Here we go. Not Like Us cannot be viewed in isolation, but must be placed in its appropriate factual context. He referenced this case right here. Immuno AG versus Moore Jankowski. All right. So statements must first be viewed in their context in order for courts to determine whether a reasonable person would view them as expressing or implying any facts. So here, that factual context is the insults and trash talking that took place via these diss tracks in the days and weeks leading up to the publication of Not Like Us. The songs released during this rap battle are in dialogue with one another. They reference prior songs and then respond to insults and accusations made by the rival artists. Rebuttals. The songs thus must be read together to fully assess how the general audience would perceive the statements in the recordings. So the references right here. But notably, the Second Circuit rejected a similar argument in Terrain. There, the plaintiff argued that the district court improperly considered the statements that he made during his war of words because they were not included in his complaints. The Second Circuit held that because the court must look at the overall context in which a statement was made in order to determine if it is actionable. The district court properly considered all statements made during the feud between the disc jockeys, regardless of whether they were included in the complaint. All right. So moreover, while plaintiff is correct that the intended audience for the recording is the general public and not a subset of rap devotees or Kendrick Lamar fans, the recordings and the rap battles were likewise released to the general public. These were not songs accessible to a select niche few, but tracks released by commercially successful artists. Like we all been saying, you guys are the 2 biggest rap artists in the game, you know, give or take J. Cole as well. Everyone watching this rap battle, seeing this whole thing play out, everyone listening to this shit, we know y'all battle. All right, so while Not Like Us may be the most popular of the diss tracks, the other songs were hits in their own right, with streams in the tens of millions or hundreds of millions. Additionally, it was not just the recording which gained cultural ubiquity, but the rap battle itself. In deciding this motion to dismiss, the court need not blind itself to the public attention garnered by this particular rap battle. The court takes judicial notice of the extensive mainstream media reporting that surrounded the release of Not Like Us and the associated feud between Drake and Lamar. Because if I'm the judge, I'm like, these are insulting my intelligence. It felt like an insulting intelligence. Like, of course, this shit. All right, let me continue reading. Accordingly, the court must consider the entire rap battle to assess whether the average listener would take Lamar's statements as objective fact or opinion. Perhaps most fatally, for the plaintiff's arguments. It would render protection for artistic expression. Oh, cook their ass, man. Talk that. No, look. Perhaps most fatally for plaintiff's argument, it will render protection for artistic expression dependent upon impermissible retroactive analysis. At the time he released Not Like Us, Kendrick Lamar could not have been aware that it would break streaming records, win Record of the Year at the Grammys, or be featured at the Super Bowl halftime show. Yet plaintiff would have the court divorce the recording from the context in which it was created because of these subsequent events. Whether publications constitute actionable fact or protect the opinion cannot vary based upon the popularity they achieve. Constitutional guarantees do not rest on such a flimsy foundation. Plaintiff counters that even if the recording was protected opinion at the time of its initial publication, UMG's republication of Not Like Us in the months following after it achieved unprecedented levels of commercial success exposes it to liability. This argument is logically incoherent. If the recording was not actionable opinion at the time it was initially produced, then its republication would not expose UMG to liability. Republication cannot transform Lamar's statement of opinion into UMG's statement of fact. Basically, just because UMG did a job to a song that was already popping, and initially it was cool, basically, why the you suing UMG? If you even have an issue with what's being said in the song, why the you suing UMG? And not Kendrick Lamar if you really have an issue. And then when to blame them, oh, you don't find a problem with what Kendrick Lamar said is because they republished the song. What the are you talking about, bro? What the hell are you talking about, Drake? Let's continue, man. Let's continue. God, this judge is cooking this nigga. All right, so tone and language. That a recording can only reasonably be understood as opinion is reinforced by the language employed in the song. Reference this case right here. Loose, figurative, or hyperbolic statements, even if deprecating the plaintiff and imaginative expression, cannot constitute actionable defamation. A court may also consider whether the general tenor of the publication negates the impression that that challenge statements imply defamatory facts about the plaintiff. So she referenced this case right here. In Rappaport, for example, the court concluded that the tone and apparent purpose of the diss track, especially considering its use of hyperbolic and vitriolic words and imagery, further reinforced for the audience that the video is not intended to reflect an accurate factual assessment of Rappaport. The district court faced no difficulty concluding that the context of the diss track video reasonably signals to viewers that the challenge statements are the prejudiced, opinionated views of the Barstool defendants. So the Second Circuit affirmed the district court's analysis, concluding that the nature and tone of the surrounding language can function as a strong indicator to the reasonable reader that the statement is not expressing or implying any facts. So Not Like Us is replete with profanity, trash talking, threats of violence, and figurative and hyperbolic language, all of which are indicia of an opinion. A reasonable listener would not equate a song that contains lyrics like "Ain't no law, boy, you ball boy, fetch Gatorade or something. Since 2009, I had this bitch jumping" with accurate factual reporting. Accordingly, the reasonable listener of Not Like Us would conclude that Lamar is rapping hyperbolic vituperations. So, plaintiff contends that in determining the lyrics, if the lyrics of Not Like Us express fact or opinion, the court must consider the subjective views of listeners, as well as commentators in rap industry and the press, who understood the recording, video, and image as an attempt to convey a precise factual message, pedophilia, about Drake. The amended complaint cites extensively to comments and posts from YouTube and Instagram that expressed the belief that the recording had exposed the truth and that Drake was truly was engaged in pedophilia and sexual violence against children. All right. But distinguishing between fact and opinion is a question of the law for the courts to be decided based on what the average person hearing or reading communication would take it to the mean, referencing this Davis versus Boheim case. The dispositive inquiry is whether a reasonable listener could have concluded that the statements were conveying facts about the plaintiff. So courts make that determination by looking at the full context and surrounding circumstances of the challenge communication. Once again, it's all about context, but To continue reading, the court holds, based upon a full consideration of the context in which Not Like Us was published, that a reasonable listener could not have concluded that Not Like Us was conveying objective facts about Drake. The views expressed by users Kyle Ken, Mr. Ride, Nebula, and other YouTube, Instagram commentators quoted in the complaint do not alter the court's analysis. In a word in which billions of people are active online, support for almost any proposition, no matter how far-fetched, fantastical, or unreasonable, can be found with little effort in any number of comment sections, chat rooms, and servers. So basically saying, nigga, anybody can go through, can nitpick or cherry pick comments to push any narrative that they want to. So don't come to me some cherry picking shit. If you find the people that said something about you being a pedophile and put it in the court and act like, oh, see, people really believe I'm a pedophile because they're saying this in comment section. The judge like, man, get the fuck out of here. Get the fuck out of here. All right. So once again, in the world, so it says that some readers may defer defamatory meaning from a statement does not necessarily render the inference reasonable and under the circumstances. So the artist's 7-track rap battle was a war of words that was subject of substantial media scrutiny and online discourse. Although the accusation that the plaintiff is a pedophile is certainly a serious one, the broader context of a heated rap battle with incendiary language and offensive accusations hurled by both participants would not incline the reasonable listener to believe that Not Like Us imparts verifiable facts about the plaintiff. So image and video. To the extent that the plaintiff alleges that the image and video are independently actionable, the court holds that they too constitute opinion. The image is the album cover for the Not Like Us. It thus shares the same overall context as the recording itself. The image is designed to reinforce the message of the recording, and as the court has already found, that the message is protected opinion. So additionally, the image itself, with its overlay of more than a dozen sex offender markers, is obviously exaggerated and doctored. No reasonable person would view the image and believe that, in fact, law enforcement had designated 13 residents in Drake's home as sex offenders. The figurative imagery accompanying the music video also constitutes protected opinion. Plaintiff alleges, for example, that the video depicts a prolonged shot of a live owl in a cage, protecting the mention that Drake belongs behind bars. So an image of a caged owl cannot reasonably be understood to convey a factual message. Similarly, depicting Kendrick Lamar playing hopscotch while singing the A minor lyric is not suggestive. It's not suggestive of objective reporting. So mixed opinion. All right. We almost done. So although pure opinion cannot constitute actionable defamation, mixed opinion, which is an opinion that implies that it is based upon facts which justify the opinion but are unknown to those reading or hearing it, is actionable. They reference Hilber once again. So mixed opinion holds the implication that the speaker knows certain facts unknown to his audience which support his opinion and are detrimental to the person about whom he is speaking. So whether statements constitute mixed opinions presents a legal question. So which must be answered by considering in the context of the entire communication and of the circumstances in which they were spoken or written, whether the average listener would reasonably understand the opinion as applying the assertion of undisclosed facts justifying the opinion. It reference Cooper versus Templeton. So just as the overall context of Not Like Us forecloses the argument that its lyrics can be read as factual assertions, that same context negates any implication that Kendrick Lamar's lyrics are based upon undisclosed facts. So they say holding where statements are made in circumstances where an audience may anticipate that the use of epithets, fiery rhetoric, and hyperbole inference cannot reasonably be drawn that assertions were based on undisclosed facts. In the context of this rap diss battle, no reasonable person would listen to Not Like Us and assume that Lamar uniquely had access to credible, provable facts that reveal Drake to be a pedophile. So the plaintiff's arguments that the lyrics to Not Like Us can be read to suggest Lamar's reliance upon undisclosed facts is unavailing. Plaintiff first posits that the line "Say Drake, I hear you like I'm young" indicates that Kendrick Lamar heard from outside sources evidence confirming that Drake is a pedophile. as discussed infra. However, that ignores that the line is reasonably understood to be a direct response to Drake's challenge to Lamar and Tell-Made Freestyle to talk about Drake like a young girls. So Heard It on Button podcast has got to be true. This lyric clearly prods Lamar to discuss pre-existing rumors about Drake's interest in minors. All right. Lamar's responsive lyrics are thus akin to the accusation of pedophilia in terrain that Second Circuit concluded constituted pure opinion. There, the Second Circuit Court concluded that a reasonable person would understood based on the context that the defendant disc jockey was using the term pedophile in response to directly pertinent comments made by plaintiff during their war of words and was not relying upon undisclosed facts. Basically, it's already been talked about before this battle was going on. Drake knew himself that it was rumors out there about him being pedophile to the fact that he talked about it himself first in the diss tracks between both of them. So Kendrick Lamar is not the first person to say some shit about you being a pedophile. It's already been out there. The judge is making that clear. So the plaintiff next points to the lyrics rabbit hole is still deep. I can go further, I promise. So plaintiff argues that a reasonable listener could view this lyric as suggesting that Lamar has specific evidence to back up his assertions of pedophilia. It is not at all clear that this is a natural reading of this lyric. All right, so if the line was susceptible to such an interpretation standing alone, however, no reasonable listener could understand it in this way given the overall context. Indeed, during this rap battle, Drake and Lamar each used similar hyperbolic, threatening language. But don't lie about me, I won't tell the truth about you. Your darkest secrets are coming to light. That's from Drake. I've been in this industry 12 years, and I'm gonna tell y'all one little secret. It's some weird shit going on, and some of these artists be here to police it. I got your fucking lines taped. Excuse me. I got your lines tapped. I swear that I'm dialed in. What about the bones we dug up in that excavation? This kind of posturing in rap diss track does not make such lines more likely to be understood by the ordinary listener to be anything but pure opinion. All right. So second degree harassment. New York does not recognize a civil cause of action for harassment. New York does not recognize the cause of action to recover damages for harassment. They just reference in different cases. A person commits harassment in the second degree when they hold the intent to harass, annoy, or alarm another person and engage in the course of conduct or repeatedly commit acts which alarm or seriously annoy such other person and which serve no legitimate purpose. So plaintiff alleges that the recording, video, and image individually and collectively provide a call to target Drake, including through violence. And the defendant's course of conduct in publishing specific and unequivocal threats of violence has placed plaintiff in an unreasonable fear of physical harm. This state criminal statute does not provide a private right of action. However, accordingly, plaintiff fails to state a claim for harassment. All right. So that's basically all the that Drake was talking about with his child being in school and being teased, I guess, his house, things going on with his home, as far as the shooting and all that stuff right there. I'm skipping past that point. All right, let's keep this thing pushing down here. Boom, boom, boom. All right, so New York's general business law section. So plaintiff's final cause of action brought under section general business law fares no better. So deceptive acts or practices in the conduct of any business, trade, or commerce, or in the furnishing of any service. Plaintiff alleges on information and belief the defendant engaged in deceptive acts and practices in the conduct of business, trade, and commerce by covertly financially incentivizing third parties, including music platforms and social media influencers, to play, stream, and promote the record. All right, this is the bot shit. This is paying streamers. This is all those things. This is that section right here. That's what they're talking about over here. So as one example, plaintiff alleges that he understands that UMG covertly paid a popular NFR podcast to promote the recording and publish podcast episodes and other content about the recording. On information and belief, plaintiff further claims that UMG uses resources to incentivize third parties to use bots to stream the recording and subsequently extol the recording streaming numbers on Spotify while knowing that millions of the streams were false and fraudulent. Lastly, the amended complaint alleges that UMG paid at least one radio promoter to engage in pay-for-play arrangements or payola all right, of the recording on New York radio stations. So to successfully state a claim under Section 349, a plaintiff must demonstrate that the defendant's deceptive acts were directed at consumers, the acts are misleading in a material way, and the plaintiff has been injured as a result. All right. So plaintiff asserts that the defendant's deceptive acts and practices were intended to inflate the public's view of the recording's popularity and success, which would lead a reasonable consumer of music to be materially misled. The defendants first argues that the plaintiff uses an improper pleading device, as its Section 349 allegations all rest upon information and belief and do not go beyond pure conjecture and speculation. All right. So plaintiff counters that the applicable standard is plausibility under this case right here, Ashcroft versus Iqbal. So they say Twombly does not prevent a plaintiff from pleading facts on information and belief in appropriate circumstances, but a plaintiff may only do so where the facts are peculiarly within the possession of control of the defendant, or where the belief is based upon factual information that makes the inference culpability plausible. In that scenario, the allegations must be accompanied by a statement of the facts upon which the belief is founded. So plaintiff argues that Pachter conditions are satisfied because the amended complaint alleges that UMG made indirect payments to a wide array of unknown third parties, and also pleads sufficient factual information concerning UMG's scheme, including examples thereof, contemporary reports, as well as UMG's past practices. So at oral argument, plaintiffs stressed that Not Like Us was the fastest song to reach 300 million streams on Spotify within just 35 days, which plaintiff argues is a sufficient basis for the court to infer that the defendant implemented a technique to manipulate stream totals, among other unprecedented tactics, to reach unprecedented rocketing up the streaming chart. Okay, the court disagrees. To allege that UMG implemented covert practices to manipulate streams of Not Like Us and inflate recordings' perceived popularity, plaintiff relies on tweets. Plaintiff relies on tweets by individual users and reporting from fans to allege that UMG utilized covert tactics to my bad, this is funny as alright, so let me read that shit again. So to allege that UMG used bots, it says plaintiff relies on tweets by individual users and reporting from fans to allege that UMG utilized covert tactics to manipulate streams of Not Like Us. The court finds plaintiff reliance on online comments and reporting insufficient to meet the plausibility standard, finding that when it comes particularity and plausibility to the experience of a no-name person from a small set of anonymous customer reviews does not add much heft to the complaint. They reference in this case up here, all right? So, a small sample of users' possible experience communicated through tweets and other anonymized commentary fails to establish a plausible inference that UMG manipulated listeners into streaming Not Like Us instead of Drake's music. Alright, we almost done. So while these covert practices of providing financial incentives to undisclosed third parties and leveraging of business relationships, if they exist, may be facts that are peculiarly within the possession and control of UMG, plaintiff's allegations based on what boils down to unreliable online commentary do not form a sufficient factual basis such that there is a reasonable expectation that discovery will reveal evidence of illegality. So ultimately, the plaintiff fails to provide any facts or circumstances that will make it highly plausible that UMG conducted such covert business tactics. Even if the court accepted plaintiff's pleadings on information and belief, plaintiff still has not stated a claim for relief under Section 349. Plaintiff has not sufficiently alleged deceptive practices that are consumer-oriented. Under New York law, the term consumer is consistently associated with an individual or natural person who purchases goods, services, or property primarily for personal, family, or household purposes. So they reference this up here. While Section 349 does not preclude an action brought by one business competitor against another, and it is at its core a consumer protection device. All right. So the amended complaint does not indicate how any of the deceptive practices alleged utilized by UMG harm consumers. For example, The amended complaint does not allege that consumers paid more than any otherwise would have for a product, purchased a product that they otherwise would not have because of misrepresentation regarding the product, or otherwise received less in value for any purchases that they didn't make. So, all right. So holding section 349 is limited to deceptive practices that pertain to an issue that may bear on consumers' decision to participate in a particular transaction, or which undermine a consumer's ability to evaluate his or her market options and to make free, intelligent choice. So the amended complaint is what is somewhat vague as to who the class of consumers is and what the products, goods, or services they are purchasing. It is not clear how the alleged redirection of Spotify users who are searching for other unrelated songs and artists to the recording would amount to actual harm of consumers or any limitation of their choices. At most, the allegation suggests that UMG engaged in practices to make Not Like Us seem more popular than it actually was, without connecting that activity to any consumer harm. Such practices, without more, do not state a claim under Section 349 of the GBM. Conclusion: the defendant's motion to dismiss is granted. The clerk of court is respectfully directed to terminate ECF NOS .42, 70, and 81 and to close the case. Case closed. The judge tosses Drake's claims of defamation and all the other shit he was saying. Another L that could have been avoided. He just mind his business, took a little vacation, do your little thing, vibe on out, and just come back with good music. Feature fans music. This did not have to happen. This did not have to happen. This shit did not have to happen. What the fuck was Drake doing, man? What y'all saying in the chat? Y'all laughing? Drake should be ashamed of himself. Drake needs to stop listening to tweets. Anyone in this camp needs some real friends. That's what it came down to. Like all this shit. He really was gathering information from fans. They gassed him up to do this stupid ass lawsuit, trying to find some type of W, some type of victory, when he should have just took his L, lick his wounds, duck off, made people miss you for a little bit. If he'd have just been quiet and then came with that "What Did I Miss" song, it probably would have hit harder, and things could look different for him. But his ass been crying for a whole year straight. And it did not have to go this way. Someone said Drake cheddar bobbed himself. The JBP gonna have a field day with this? Facts though. Taylor May was the real MVPs of the court case. Oh man. Taylor May, yeah, facts though. So how long do we think Drake is going to keep losing from a rap battle 1.5 years ago? Facts, man. I'm reading what y'all saying in the comment section. Once again, Drake allowed his ego to overestimate the situation and earned another loss. Why? Drake isn't that smart, tailor-made. Kendrick's lyrics were bulletproof for a defamation lawsuit, saying, "I heard." This mess should never went to the courts in the first place. Facts, man. After the judge read those lyrics, he wanted to meet Kendrick next. She wanted to meet Kendrick next. I'm sure she does, because I know the judge was enjoying this shit. Drake's lawyers did Birdman hand rubs with this case. They knew it was a loser case, but got the bag anyway. Facts. Drake's lawyers, they took his ass up and threw there for this stupid ass case. They knew it. They knew they could play upon his ego to keep this shit going. They knew it. They knew that. Kendrick said PDF not filed, not weirdo. This court case should be used as a prime example that Larry is a bad gambler. Kendrick and UMG, Drake's lawyers are the real winners. Facts, Drake's lawyers bring up a bag. What's the chances that Larry takes this L gracefully? He not taking it gracefully, dog. And his fans gonna get. I'm going to be watching when I get off. I'm going to see what's going on social media, and I'll come back to y'all with some reactions, because I know his fans gonna be crabbing and crying. It's funny seeing how they were trying to break down the hidden messages in his most recent song. Let me switch to this angle. But they were trying to break down the hidden messages in his whatever that shit he got going on with the live streams and stuff, saying, oh, the industry is after Drake and he's got the Pinocchios and all that. Man, all that out here. Just put out music, Drake. You ain't that deep, my boy. Certified crybaby. Certified crybabies is crazy. What y'all saying? What y'all saying? What y'all saying? Damn shame. 616 in LA sample and get cleared. Like, I love that. Yeah, that track was fire. That's one of the best tracks. Meet the Gram Euphoria, depending on your perspective, won the battle. Not like us. That was just kicking Aubrey's corpse. Aubrey fans mad about Aubrey being called a pedophile, but they skipped over this verse. I know you're referencing Telling May. I like that. I don't get that shit, bruh. Nitpicking just to push a narrative. I understand just to win the fight, win the debate. But come on now. Any reasonable person that's really using their brain knows that this is all, bruh. Someone says they not like us. I'm so mad at Drake for this lawsuit. Kendra's mole was Drake's writers because why did Drake say that? I know you're referencing the Telling May shit. Someone said, let's go, Judge. It's time to start playing Meet the Grams on the loop. Judge Vargas did her job. The judge dissected the bar. That's the funniest part to me. That's the funniest part to me because I'm just visually thinking about the judge like preparing that whole shit and having fun. I know this case was fun for her. Family Matters was so cap. The Heart Part 6 was cap too. Now hopefully Drake would go somewhere, rest, and deal with his ego. Hey man, if Drake would have chilled out, then he probably would have been good right now to actually roll out an album. But now he has to deal with this embarrassment. You did not have to deal with this embarrassment. You did not have to take 2 L's. Well, it's been more than 2 L's, but this is like, this was an L that he did not have to take. An L that he did not have to take. Someone says he should have, Gina's Universe says he should have studied rap battles harder, right? Because like, obviously it's a rebuttal. It's like the judge studied the rap battles more than him. Because he wanted to play upon the ignorance of the judge, dog. Like, if once again, I told y'all, if I'm the judge and listening to everything that they're telling me, I'm like, y'all think I'm stupid. Y'all must think I'm slow as hell. That I can't break down what's going on. You came to court to play on my ignorance of rap and thought that I wouldn't be able to dive in and figure this shit out and understand what was going on. You were trying to, since you couldn't win the actual rap battle, you was trying to make me be the referee. So if I'm the judge, I feel like you blame me, right? So that I'm gonna make sure you lose more money from your lawyers and drag this shit out. Drag this shit out and then dismiss this shit and go crazy on write my own little diss song to your damn lawyers in this damn opinion that I'm gonna go ahead and file. Like, if I'm the judge, I'm like, you playing upon my damn intelligence. I feel bad for the OVO label. Nobody finna come out. J. Cole was gonna take the biggest L this rap battle over time had Drake not sued. We would have gave Drake hell for a minute, but he survives it. But now, worse than what 50 did to Ja. Damn. I think the judge said her kids helped her figure it out, what was going on early. Oh, okay. Shout out to her kids. Shout out to her kids, like, nah, ma, that Drake tripping. They probably didn't say nigga though. Certify that wah. Hey man, Iceman is definitely not coming out now. He gotta push that back. It's officially over, finally. Yes. Goddamn, Drake reminds me of that bicycle meme now. He did it to himself. Facts. I study court losses for a living. Referencing to Drake saying he studied rap battles for a living, man. Drake got humiliated all year. This is the nail in the coffin. The nail in the coffin, man. Listen, dog. This has been interesting. I got a lot of content I got to roll out to y'all. I would not be surprised if Maul sheds actual tears because his idol lost. Dog, I'm going to keep saying it because this did not have to happen. He didn't have to go through this. But once again, Lil Durk dropped one of the hardest lines. He'll still be alive right now if you didn't gas him up. All the on social media, all the that the Drake fans was doing their best to try to win this rap battle. Academics indirectly letting Grand Wizard Chat nigga, who I don't think is at all, letting Grand Wizard Chat nigga run his academics TV page to push propaganda and feed Drake. I'm sure all that went to Drake's head and Drake was just feeding that shit to his lawyers or however. I'm speculating, I don't know, but trying their best to use this to find a narrative to push and then send that shit to the judge, act like that shit was actual fact. That shit was crazy. That shit was crazy. This is a W for hip hop because if this case would have went through, not only hip hop, but just music period, they were going to have to fact check every single song that came out to avoid being sued over lyrics. They were going to have to. Every single album was going to be whack. It was going to be no more diss songs that were going to be publicly released. And these labels want to make money. I seen someone say some in one of my comment section, oh, if y'all still want diss songs, then don't let the labels publish them. They can still have the diss songs, but don't publish them. Man, that's stupid. No. These labels want to make their damn money. These artists want to make their damn money too. Rappers need to rap. Hip hop is about competition at its height, lyricism, going back and forth battle. I fuck with all that, man. I love that, and I'm glad that this is not going to take that away from us as the viewers, as the fans. So people that were supporting this lawsuit just for the fact of supporting Drake and then trying to claim that you fans of hip hop too, out of here. You ain't no fan of hip hop supporting this shit, understanding what it would have done to hip hop. Ain't no way. So shout out to the judge for understanding what's going on and having to police Aubrey's emotions. Just go make music, bro. Vibe out. Deal with your little hoes. Make music. And leave us the f alone with this stupid ass shit. But y'all let me know what you got to say in the comment section below. I'm going to go ahead and get up out of here though. Make sure y'all go and watch the playback if you missed it from the beginning. I went through all the paperwork and all that good stuff. I appreciate y'all hanging with me. Hit the notification bell. I got a lot of content. I got about at least 5 more videos at least that I'm about to be dropping. I got to push out to y'all, man. But I appreciate y'all rocking with me and all that good stuff. I'm out, y'all. Hit the like button on your way out, though. Hit the like button and drop a comment as well if you can, man. Just to make sure this go up in the algorithm. I'm out. Yo.